In New Jersey, parents' contribution to college costs is either agreed upon or can be determined by the court. It is a little bit of a strange situation that if you're in an intact family, you and your spouse can pretty much decide how much, if anything, you're going to contribute to your children's college education. However, in a divorce process, if there's a disagreement as to that, then the courts will ultimately decide. There are a number of factors. There's case law, but it really comes down to A, how much each parent can afford, what college the child's going to go to. People who are making $30,000, $40,000 can't be expected to pay $75,000 a year in college expenses. The courts have a number of different remedies, including having the children apply for as much financial aid and loans and grants and scholarships as possible to defray the costs. But in general, it's always best to settle these cases. In many cases, when people get divorced and the children are very young and the future is unclear, we state that in or around the junior year of high school, the parties will discuss and attempt to agree and maybe go to mediation on this issue. But at the end of the day, if the parties disagree, the courts will decide. They may even have a plenary hearing on the issue, a trial, to determine who has what money available to pay for college. But there is the potential for the court to obligate parents to pay for college education expenses, even in those cases where the parents might not normally contribute if they were in an intact family. So this is a issue we deal with a lot. So if you have any questions whatsoever about your child's college education costs, please contact us here at Callagy Law, and we'll certainly explain all of your rights, your obligations, and how you go about either making your spouse pay their appropriate share or to determine your fair share of college costs.